So today I'm joining you from Mullingar District Court, and we're going to talk about the issue process. So the issue process in the District Court is statutory in nature, and it begins in the Petty Sessions Ireland Act. But before we talk about the District Court summonses, I just want to show you what gives us the authority to prosecute in the first instance. Now, this authority starts in the Circuit Court. So it's Article 30.3, which says, all crimes and offences prosecuted in any court constituted under Article 34 of the Constitution, other than a court of summary jurisdiction, shall be prosecuted in the name of the people and at the suit of the Attorney General, or some other person authorised in accordance with law to act for that purpose. So this constitutional provision provides that we can prosecute in the Circuit Court. But to get to the Circuit Court, we need to first go through the District Court. So what gives us the right to prosecute offences in the District Court? So first of all, we need to give information to a justice. So Section 10 of the Petty Sessions Ireland Act, without going into it in detail, allows us to give information to a justice for the purposes of having a summons issued, right? So whenever information shall be given to any justice that any person has committed or is suspected to have committed any treason, felony, misdemeanour or other offence within the limits of jurisdiction of such justice, for which such person shall be punishable either by indictment or a summary conviction, right? It shall be lawful. We can skip this part here because that refers to matters that are not applicable. It shall be lawful for such justice to receive such information or complaint and to proceed in respect of the same, subject to the following provisions. So this obligates a justice to issue a summons once we give information to them. Now that information can be given orally, written, or written under oath. So that's a discretion of the justice. They can receive it by our voice, or they can turn around and say, look, I want you to write that down and swear on it and sign it. And that's where their discretion finishes. But the obligation to issue the summons is set down in this piece of legislation. Now, I just want to exhibit what is a justice. So we have to go to section 44, and the word justice shall mean justice of the peace and shall include the chief magistrate for the time being, or the borough justices of any corporate town. So it's a justice of the peace. Now that was back in 1851. We don't have justices of the peace anymore because in 1924 our courts were established under the Courts of Justices Act. So section 77 states, the District Court shall have and exercise all powers, jurisdictions and authorities which immediately before the 6th day of December 1922 were vested by statute or otherwise in justices or a justice of the peace. So in short, a District Court judge can exercise the Petty Sessions Ireland Act, Section 10. Now, Section 88 of the Courts of Justices Act, which provides a provision to the Minister of Justice to appoint peace commissioners, states at subsection 3, a peace commissioner shall have all the powers and authorities which immediately before the 6th day of December 1922 were vested in a justice of the peace. That authority extends to summonses, warrants, taking informations, and other provisions which aren't applicable to the issue process that we're talking about today. Another important section of law to remember is Section 177 of the Criminal Justice Act 2006. So when a summary offence is committed against a person by a state employee, we have 6 months to issue a summons against them to initiate a prosecution. If the 6 months expires and the matter is of summary jurisdiction only, we can't do anything about it. The time limit is passed. But a lot of offences are indictable, which means that we can have summonses issued after the 6 month period. Now, to remove the restriction, because the Petty Sessions Ireland Act works up until 6 months. But the Oireachtas has provided the people of Ireland with a section of law to remove that 6-month restriction when the matter concerns an indictable or scheduled offence. So these are offences which are indictable in nature, which can be tried in front of a jury. And as I said, most offences in Ireland are indictable. So we have to attach this piece of legislation to the summons and the information if the matter is over 6 months and it's indictable in nature. So we are well protected, people, for taking on corrupt state employees. The Oireachtas has created the legislation for us to use. But unfortunately, many citizens and people living in Ireland, they don't use the legislation because they don't know about it. And the courts don't tell them about it. Solicitors and barristers don't want them to know about it. And of course, state employees would rather nobody knows about it. And they probably wish this legislation was never created in the first place. But unfortunately, since 1924, we have put all our faith in Garda Síochána, and the DPP weren't around at that time, but the Attorney General, and we have given them our trust, but they're not holding themselves accountable. So this is the legislation that allows us to engage with over 6,000 peace commissioners through 100 district courts all over Ireland, including up to, I think it's between 70 and 80 district court judges. We have absolutely no excuse now to initiate proceedings against anyone employed by the state who does not fulfil their statutory duty and who have contravened criminal law. And it's up to us to identify how their actions have breached criminal statutes. So this is the issue process. It's grounded in our constitutional right, and we have to exercise statutory law. In part 2, I will be showing you how to draft your information and your summonses, and then we'll talk about the service and legislation then as well. But this is how we get started. Section 10 of the Petty Sessions Ireland Act, Section 77 of the Courts of Justice Act, Section 88 of the Courts of Justices Act, and for removing the 6-month restriction is Section 77 of the Criminal Justice Act, and it's all grounded in Article 30, subsection 3 of the Constitution of Ireland. So that provides us a jury in circuit courts, and this provides us with starting our matters in the district court. I will also show you how to take a matter into the High Court without any statutory provisions, and all we need is to give evidence to the judge, and the judge is obliged to summons a jury to hear the evidence and let the respondent reply. So if there's any questions, please ask. I'll put up some links into the description, but this is it. This is the legislation that empowers the people of Ireland.